All persons having business before the Honorable Associate Judges, now presiding of the District of Columbia Court of Appeals, draw near and give your attention. God save the United States and this honorable court. This honorable court's now in session. Please come to order.
Thank you. Good morning. We have two cases on the calendar this morning, and we'll take them in the order they appear. The first case is Maxim Reagan Smith versus United States. Counsel, you may proceed.
May it please the court, Justin Amechi Okezie for Mr. Maxim Smith, appellant. I'd like to reserve 3 minutes for rebuttal. Your Honor, the trial court made a number of errors in this case, all of which require that Mr. Smith receive a new trial. First of all, the trial court refused to allow Mr. Smith to waive an enhancement, although the case law in this jurisdiction clearly states that he has the right to do so. He was forced to be tried on a bias enhancement, although he asked to waive it or have the trial judge decide it. That was rejected by the trial court on a number of occasions, and therefore at his trial, the N-word and other types of vile words were used and introduced in his case, and that requires a reversal.
Can I ask you, why are you referring to the bias-related aspect of the allegations against your client as a sentencing enhancement rather than an element?
Yes, Your Honor. I realize that the government has mentioned, cited some case law from the Supreme Court that discusses the use of the term offense or crime, but this court has said, has explained that any enhancement that has to do with enhancing a sentence, in other words, it's a sentence enhancer, it's not its own individual charge under our case law, meaning it does not stand alone. It only goes to enhance the sentence when the person is convicted of an underlying substantive offense.
Well, let me ask you, is that, in your view, ultimately an issue of legislative intent? What the legislature intended about who would make the finding on this bias-related aspect of an alleged crime?
Well, Your Honor, I'm not sure when every enhancement was passed. I know some enhancement predated Apprendi, which was in 2000. So perhaps at the initial enhancements that were passed before that, the legislature had conceived of the judge doing it. But when Apprendi came down, then at that point, the Sixth Amendment right gives the defendant a right to have the jury decide it if he wants to have the jury decide it.
Right. But so my question is, so with respect to this enhancement, if you want to call it that, or element, if you want to call it that, of an aggravated crime, what do you think? This was created before Apprendi. So I think it was in 1990, if I'm recalling correctly. So what do you think the legislature intended? Who did you think the legislature intended originally to decide this? A judge or at sentencing, or the jury at the time of returning a verdict?
I don't think the legislature had anything in mind of that nature. That's a very, I think, specific kind of a legal issue that I think at the time, of course, judges were doing it, but I think that the legislature didn't necessarily intend for one or the other to happen. The court has its own way.
Part of the reason I ask is if you look at the wording of the enhancement, it does say found guilty is part of the wording of the provision. I say enhancement, that's what's at issue in part, but it does refer to whether someone is found guilty of committing a bias-related crime, which tends to suggest, at least arguably, that the legislature intended that the jury decide the matter.
No, I understand Your Honor's point. Well, there's also case law that goes back before and after Elaine, that goes back, which is always under our case law and under the way that it's even codified, it's called an enhancement, and the word enhancement is used in different situations. That essentially it stands on its own. As to whether the jury or the judge should decide it, I think Apprendi changed everything. It was a watershed case, as the court knows, and at that point,
well, I guess whether Apprendi, the questions I'm asking are about whether Apprendi did change anything. Because if the legislature before Apprendi intended that the jury just make this determination, then Apprendi won't have changed anything because that already will have been required. And that's what I'm trying to figure out. And there are other provisions that aren't codified as separate crimes that increase the penalties for crimes. There are senior citizen provisions, and there are others. And we have a body of law about what we should do, this court should do, if trying to figure out whether the legislature intended those to be found by a jury or intended them only to be determinations made at sentencing to increase sentence. And are you familiar with that body of law? There are cases like Fields that address that say things like, the assumption is that if it relates to prior criminal history, then maybe the idea is that it's a sentencing enhancement to be found. The legislature will have intended that it be a sentencing enhancement found by the judge at the time of sentencing. But if it relates to the circumstances of the commission, surrounding the commission of the crime, then the assumption is instead that the jury will make the finding. Are you familiar with any of that law?
I think generally, Your Honor, but I'm struggling to understand exactly. Perhaps the court can reframe it for me so I understand how it in this case has what the context is, because we have Edie, we have Williams, we have other cases that have decided that in this situation, even if the defendant has a right to present it to the jury, he or she can decide not to do so. So I'm not quite sure.
Here's the reason I'm asking. Yes. The reason I'm asking that question is because the set of questions is because the cases like Edie and Williams involve, or perhaps involve, enhancements, to use that term somewhat carelessly, that the legislature may have intended that the judge find. And so if the defendant has a right in those cases out of Apprendi, then perhaps at least Edie suggests, and I guess Williams, building on Edie, suggests that a defendant can forego that right. But what's less clear, I guess, is if the legislature all along, independent of Apprendi, said this is an element that the jury, this is essentially an element that a jury is going to have to find in every case. That's a pre-Apprendi principle. Then it gets less clear whether Edie and Williams are applicable, and instead the government relies on a different line of cases that say, the defendant doesn't have a right to stipulate away elements of crimes, or have a partial bench trial or partial jury trial on elements of crimes or parts of crimes. And so that's part of why I'm trying to figure out which side of Edie and Apprendi and Williams this case fits on. To my mind, at least potentially turns in part on whether, independent of Apprendi, the legislature all along wanted the jury to decide this question. And because if that's true, there is a body of law that suggests that maybe the defendant doesn't have a right to say, well, the legislature wanted the jury to decide this, but I want the judge to decide.
I understand Your Honor's point. I think that that's not the case here, because essentially if the court's looking, for instance, at Goodall, which is the case that the government relies on, I think to their detriment, Goodall and a FIP, a felon in possession offense, in the actual elements, these are the elements in the DC code that spell out the actual offense itself. They state the person has to have this disqualifying status as being someone who has a prior felony or something of that nature. In this situation, there's a completely different standalone offense, which is ADW, and then you have the enhancement, which, by the way, I'll just cite Oboye, Your Honor, which is a case that dealt with an enhancement, and also in the context of a hate crime. That's 121 Atlantic 3rd 1245, 2015. In that case, this court characterized this as an enhancement, and it did not characterize it as a substantive element of an offense. So I think looking at all of the enhancements, including our enhancement statute that we have, that there's many areas of the DC code where enhancements are referred to differently from substantive offenses. Even in this case, the trial judge actually calls it an enhancement at one point while she's discussing it with us on the record, and the government in their plea offer, they agreed to waive the enhancement. So it's been called an enhancement up until the point where the government didn't want to call it an enhancement anymore. Then they called it an element of the crime so that they could then prove it to the jury to my client's detriment. So I don't think that there's any.
I understand. Let's take like the while armed provisions. They don't create. They're not in the code. The while armed enhancement isn't like described inside of each offense and created as here's an element. There's a felon element of robbery. Here's the crime of robbery. It has the following elements. There's also the aggravated crime of robbery while armed, and here it's elements, and while armed is an additional element. They're not codified in the code that way. There's just a general provision that says if you commit certain offenses while armed, the penalties are greater. Is it your view that those are sentencing enhancements that and that a defendant has the ability to essentially either stipulate them away or have a bench trial on the while armed part of every crime, so that a defendant could say, look, I don't want the jury to hear that, you know, there was a gun involved. I want instead to have a trial only on the elements of robbery, and the while armed part of it, I'm going to forego my right under either what the legislature intended to be elements or under Apprendi, and we'll have that handled by way of either stipulation or bench trial on that kind of component of the allegation.
Your Honor, excellent question, Your Honor. On the while armed provision, I'm not completely prepared to discuss that because although it is an enhancement provision, it might be somewhat different. But I will tell the court that overall, the reason why that would be different essentially is that when the gun is being used, a gun can be introduced as evidence in a robbery case. So it's not as though the body of law like Edie and Williams that want to find a way to protect the defendant from undue prejudice being admitted in his case, that the defendant would necessarily be able to get around that situation in that particular case. So it depends.
The government argues that the same is true here, and that the evidence of the use of the N-word was relevant not only to whether the enhancement should or should not, again, using that term very loosely, should or should not be imposed, but also was relevant to proving that there was in fact an assaultive crime. Do you disagree with that? You think it's not relevant to that?
No, Your Honor, I think it could be relevant, but what happened on our particular case was the trial court compounded the error, not just by ruling on the first issue, which we discussed before, but also on believing that the trial court had zero discretion to actually sanitize the use of the N-word. So unlike other cases like Williams, which is a 2016 case, the trial court in that case did 3 or 4 things to actually sanitize and try to minimize the undue prejudice in that case. So in that case, although the evidence was admitted that shouldn't have been admitted, the trial court gave a limited instruction afterwards, had the government not stress it in their case in chief, had the government only mention it in passing in the closing, and took other remedial measures to ensure that it wouldn't get out of hand. In our case, I counted the transcript, we have about 61 references either to the N-word directly or to a euphemism for the N-word or a question about it. So it was replete.
Mr. Ocasio, can I
Yes, Your Honor.
just jump back a little bit, just to ask you a question about what the judge actually decided? Because like Judge McLeese was just asking you a question, and he kept saying a stipulation or a bench trial. And in your brief, you keep referring to and at trial, we're saying we'll stipulate or we'll have you decide. Is it clear that the judge ruled that neither one of those is allowed? And my second question is the analysis different, whether, depending on whether it's a stipulation, basically to guilt of it, I guess, right? Or having the judge decide. And I know the government says stipulation would require their agreement and all of that. So I don't know if you understand that question, which was a little windy, but.
Yes, Your Honor. So the first point, just to make the record about the first point, yes, Your Honor, we had alternatives. The first alternative we would have preferred would be to have the judge decide it. But we also, and I said this in the transcript, if push comes to shove, we will stipulate to it. So for instance, at the June 11, 2019 proceeding, after asking this repeatedly, the judge said, I don't think the case law says that that the defendant can waive that, not under these circumstances. And that was just one example where she refused to do it. So I think that we offered either one. We would have taken the stipulation if that was what the government insisted upon, but there was just zero discussion about it. We were shut down at every juncture. We also asked in pleadings too. So it wasn't just only orally.
But is the analysis the same, whether you're stipulating or having the judge decide? Being that we offered to stipulate, I think that in this case, it doesn't really matter. But the question would be, I think that if we're offering to have the judge try it, I believe in Edie, unlike Goodall, where Goodall was a different case from ours, which is an actual element of the offense, even in Goodall, when the defendant agreed to stipulate, it would have been probably error to not allow them to stipulate to a more sanitized version of the prior conviction. In our case, we offered either one, which would have probably been a stipulation if the government wanted that.
I think it doesn't make a difference. I think either one, the defendant has a right to do, because essentially there's no prejudice to the government to have, it's not an element of the offense. There's no prejudice to the government to have the judge decide this issue if the defense gives up his right under the Sixth Amendment to have it decided by a jury. This is the government has turned a shield that the defense has into a sword they can use against us, essentially.
I'd like to ask you about that. One of the premises of your argument, even assuming this is not an element of the offense, which I'm inclined to disagree with you on, but let's assume it's not. Your argument is this is very prejudicial evidence. Well, it happens to be what your client did in the course of committing the alleged offense, and it's also very probative evidence. And it's not clear to me that the premise of your argument, that the defendant should have a right to have it sanitized, has any real force to it, given the probative value of it and given its relationship to the commission of the offense. I mean, you have this, it's a very unusual case. You have a 5'7" young man attacking a 6'4" person and behaving in a way that is very hard to understand if you don't hear any of the words that are spoken and what have you. And the government wants to show you or show the jury, look, here's what this person was thinking at the time, and here's why he was acting the way he was. And what's more, we want to show that this is a bias-related crime, and this is extremely probative evidence that it's a bias-related crime. It's very bad for the defendant. He acted in a very bad, egregious way, and juries will not like that, the way he acted. That doesn't seem to me to be the kind of unfair prejudice that would get the defendant where the defendant wants to go. Unfair prejudice is, it's usually understood that when evidence is relevant to proof of the case, that outweighs the unfair prejudice of, it's really bad for the defendant. There are many cases, we see them in the newspapers these days, where the defendant's behavior is utterly horrible. And the defendants would love to be able to say, well, let's just sanitize this trial, and the jury doesn't have to hear about a lot of that stuff. I don't think anybody thinks that's appropriate. How do you respond to that?
Your Honor, the way I respond to that is that had the trial judge known that she could have sanitized it, then she would have likely sanitized it. She didn't know, and she operated under a false impression. And the way I can show that, Your Honor, is number one, when it came to the F word, which he used at one point, she allowed on the scene with the police, she allowed that to be sanitized because she thought she could. When it came to his jail calls, some of that was sanitized at first because she thought she could. When it came to this, she thought she could not sanitize it. And therefore, under our case law, it was an abuse of discretion because she relied upon inaccurate and incorrect legal principles to think she couldn't sanitize it. Now, the number of times it's used in the closing argument, not just saying the word, but saying the word in order to then have the jury judge Mr. Smith as being this person who's vile and racist in his heart, which was really not the core of a self-defense or even assault case. There are other things.
Does it matter that the jury ended up not convicting your client on that count or that enhancement, whatever you want to call it?
I don't think it matters because he wasn't acquitted on the count. So that's one thing. The second thing is juries compromise all the time. And to be frank with you, part of our defense was to fight one war on two different fronts, because we had to fight the war of, did he commit this offense, or did he have self-defense for the offense? And number two was it motivated by race? So what ends up happening is the government made us really carry a higher burden. And with every time the N-word was mentioned or the reference was mentioned, it actually disparaged him more and more and made him to be a villainous character. He testified in the case. So essentially the jury is now viewing him from that perspective. In another case, Judge Glickman, yes, looking back at it, perhaps if Your Honor was the trial judge, that if the court said, look, looking at it, I decide after doing my analysis, I think that it should come in this amount of times, we wouldn't be in the same place right now.
Would it be that different if it were sanitized? Would the effect have been different from your perspective?
It would have been extremely different, Your Honor, because in the closing argument, the government pounds on this and they repeat it over and over. And our case law, Morton versus United States, explains that a prosecutor stressed upon the centrality of a particular evidence in closing tells a good deal about whether the admission of the evidence was meant to be and was prejudicial. So the closing argument was one issue. The fact that they were allowed to use another N-word incident from December, which shouldn't have been allowed in, which the judge initially had ruled was not admissible, that compounded the error.
Can I
And
ask you
also,
to be concrete? I want to make sure I understand. Now, let's assume for a moment, I know you don't agree with this, but let's assume for a moment that your client didn't have a right to have the judge decide the question of whether this was a bias-related crime. And let's assume for a moment that your client also didn't have a right to stipulate to the bias-related crime in some way, like in abstract terms, by saying, you know, jury, here are the elements. One of the elements is a bias-related crime, but the defendant stipulates that this was a bias-related crime. Assume none of those things are true. And so the jury was going to have to decide whether this was or was not a bias-related crime by considering the evidence about it. How would it have been, how would assuming on those assumptions, which I know are not your principal arguments, but I just want to make sure I follow, assuming those things were true, do you think still the evidence could and should have been sanitized in some sense? How would that have been done?
well, Your Honor, it happens all the time. And the court decided Romero about last week. In that case, I believe Your Honor was.
Leave aside for a minute a different case. Just be concrete.
Okay.
Just tell me what you think. If I'm the trial judge and I say, look, the jury's going to have to decide whether this is a bias-related crime. They're going to hear that the element, the components of that include things like race. So they're going to hear evidence about whether this crime was motivated by racial bias. And the government wants to put in evidence that your client used the N-word. Do you think that somehow the N-word could be deleted from the evidence, even if the jury has to decide whether there was racial bias here based on evidence rather than a stipulation? And if so, how would that have been done?
Not at all, Your Honor. I'm not taking that position, Your Honor. What I'm saying is that just like in any trial, where the judge has the duty to balance the evidence, the probative value and the prejudice of the evidence, the judge has to do that. In our case, if that were the case, based on Your Honor's premise, the cumulative effect of saying it 60 times versus my client would have really likely stipulated that he said the word, and that could have then the judge would then be able to say, well, look, how many times will we allow the government to mention it in closing? How will they be allowed to stress it? Just like in Williams or any other case where the evidence came in, the judge did not do that balancing here. So that's what our Roman numeral 2 is about, is the judge thinking that because of the first issue, it cannot be balanced and it could not look different. There are a lot of things can be done in the trial.
Saying it's less on that premise, which I know you have broader legal theories that suggest that the jury the case could have been handled so the jury never would have heard the term. But assuming that we didn't agree with those legal theories, your point, it sounds like, I just want to make sure I'm fairly capturing it, is even so, there could have been less emphasis on it. The trial court could have been more vigilant to reduce how much stress it got. Is that fair?
That's a fair,
Okay.
and Your Honor, under Damon Jones, we still think that's error, legal error for not exercising discretion. The question would then be, what's the effect of it? And
Right.
under Katakios and our case law, the government has a burden of proving that it was harmless. And in this case, because of the number of times it was used and how it was used, and even it didn't have to be done that way. There are cases where people have child pornography, they have drugs, they have guns, and the judge says, listen, at some point, the cumulative effect of having this repeated over and over and over again is going to influence the jury to find this person guilty, irrespective of whether or not the evidence actually is against them. It's going to come out to one thing's going to have so much of a lingering effect. It's not something we should allow in. And that's the whole point of Johnson and our 401, 403 analogous analysis here in DC that the judge just did not do in this case.
Refresh my memory. At trial, was this something that the defense asked the judge to do? In other words, judge, all right, if it's going to come in, if we can't stipulate to it, if the jury's going to hear it, at least, put some limits on how much emphasis the government can place on this, how frequently this is going to come up. Otherwise, it's going to take over this trial and really cast a pall on things. Was that sort of argument made to the judge?
Yes, Your Honor. It was made before trial in the pleadings. It was made out of desperation in court on June 11th, 2019. I'll just give you, Your Honor, a snippet of it. I asked the court to at least show some discretion to sanitize it and not make this case about that only. Make it about whether Mr. Smith assaulted somebody or not. and whether or not that person had to go to the hospital or not. And this is the critical inquiry. Thank you. I asked one time, there's another instance where I asked for sanitization, and the judge says this is also later in the same transcript, I don't think it is for the court to cut that out and sanitize it because it is for the jury. I think the jury has to hear that to be able to make their determination and their credibility findings about what was said, how it was said, and it changes when you take that out, when you sanitize it. So it does go to the jury. So she was very adamant that—
Part of the problem is that the word sanitize, this is part of why I was asking the question can seem to mean don't let that word be used, get rid of that word. And saying, look, can we at least cut down the number of references and the emphasis on it is potentially a somewhat different point. I know we're over time, but I did want to ask you about one provision that I'm just curious whether you're familiar with it and have thoughts about it, because it wasn't something that was discussed in our cases in Edie and Williams, and I don't think the United States has mentioned it, but we have a statute about jury trials, and there's also a rule about jury trials. Rule 23 is the rule, and the statute is 16705. And on the question of whether there was your primary request of having a bench trial, have the jury decide that component of the case. I'm just wondering if you have looked at that statute and have views about its possible implications or are familiar with it. Because it's in Part A, 16705 says, in a criminal case tried in Superior Court in which, according to the Constitution of the United States, the defendant is entitled to a jury trial, the trial shall be by jury unless the defendant waives in open court and the court and the prosecuting officer consent, which seems statutorily to say, if the Constitution gives you a right, whether because the legislature intended that something be an element, or whether Apprendi, that constitutional right arises out of the legal theory in Apprendi, then you're going to get that right, defendant. And the only way you can avoid that right as a statutory matter is if the judge and the prosecutor also agree to your effort to forego it. Are you familiar with that provision, and do you have thoughts about how it might bear on your suggestion that this could have been handled by way of a trial court determination of the question of the bias, whether this was a bias-related crime?
Yes, Your Honor. I am familiar with that statute, and I believe that might have been what sometimes the government relies upon for the Goodall argument. It does say in a criminal case tried in Superior Court, and we're not saying that the case wouldn't be tried by a jury. This is an aspect of the case that doesn't have to be tried by a jury. So I think that reading it literally, like Your Honor did, the criminal case was tried when we weren't interposing a waiver of the entire case on the government, only on an aspect of the case, which was something that we agreed to admit to. This happens in other situations too, where the judge will allow a stipulation on certain issues without the one party necessarily agreeing to it. So I think that
the logic of the legislature saying in A, if a defendant has a constitutional right to a trial, then by jury, then it will be by jury with respect to the case as a whole.
Well,
and then B1, and if you go to B1 of that statute, B-1, it also says that if there are multiple offenses in the case and there is a right to have a trial as to one, then the trial as to all will be before the jury unless the defendant waives and the court and the prosecutor agree. So what would be the logic of legislating that you can't pull out, the defendant can't give up the jury trial right altogether and can't give it up as to a count, but could give it up as to a component of a count? It seems a little curious that to construe the statute that way. What do you think the logic of that would be?
I think it's not curious, Your Honor, because enhancements from the initiation of, when you can look through the code in different places, they're codified in different areas with different subsections. They're not inside of the actual offense. There are offenses that have, that as an element of it, it's listed there. It's not, and therefore I think the way you're reading it, Your Honor, makes sense in general for criminal cases. And I think the logic is both sides have a right to the jury trial because that's the gravity of the case, but not on every particular aspect of it, because there are issues that come up all the time that aren't tried before the jury, although conceivably the jury could decide it. So I think that, and the fact that they can be aggregated, it says offenses. This is not an offense. This is an enhancement. It's called an enhancement by Aboye, by this court in 2015. It's called an enhancement throughout the case law, and in the code it's called an enhancement. It's not called an offense. And in fact, to enhance somebody, you actually sometimes have to, there's a different way to go about even filing an enhancement. So the fact that this Apprendi situation is the way it is, and the fact that Elaine discusses charges, I want to be very clear, that's a Sixth Amendment specific analysis that Judge Thomas wrote in an Elaine, which was because the Sixth Amendment talks about and discusses specifically the word crime. So because the Sixth Amendment discusses crime, in order to get there, to have the Sixth Amendment protect people, the case discusses the crime and says that enhancement, they do away with that distinction for Sixth Amendment purposes. It's not done away for DC Code purposes or for our purposes in DC, only for the Sixth Amendment issue when it comes to whether or not you have a right to trial by a jury or not, which he did, which he wanted to waive and he wanted to give up, and he wasn't allowed to. So that's our position.
Okay, we'll give you a few minutes in rebuttal. Let
Thank
us
you.
hear from counsel for the government.
Good morning, Your Honors. May it please the court, Ann Park on behalf of the United States. Apprendi makes clear that the district's hate crime statute creates a distinct criminal offense, and thus a factual finding of racial bias is an essential element of this new offense that must be submitted to the jury and proven beyond a reasonable doubt. The trial court therefore did not err in trying the hate crimes to the jury and in admitting evidence of appellant's use of the N-word. And because it is an element, racial bias is an essential element of a distinct hate crime offense. Under Goodall and Old Chief, the trial court did not abuse its discretion in denying appellant's request to bifurcate the racial bias element from the other elements and trying it separately to the bench, nor did the trial court abuse its discretion in denying appellant's request to stipulate to the hate crime charges.
Can I ask you, the way you're framing your argument seems sufficiently broad that I'm not sure it's consistent with the holding of Edie. Because if I understood your line of reasoning, it is Apprendi tells you that the jury has to decide this question, but nonetheless, the defendant doesn't have a right to stipulate it or bifurcate it out of the jury's decision. But in Edie, with respect to the offenses committed during release, we said, we're not going to decide whether Apprendi does or does not give defendants the right to have the jury decide this question. We don't care either way. The defendant had the right to remove this from the jury's consideration. And so it seems as though it's got to be more complicated than you're saying, or Edie has to be incorrectly decided. What am I missing?
I think actually Edie says that it's not deciding the Apprendi issue, but it, in fact, had to reach a conclusion it did. And I want to make clear that Edie and Williams, I think, can be distinguished because OCDR is similar to prior felony conviction in that it relates to the defendant's release status. And that fact has absolutely no bearing on the charged offenses in Edie or Williams. That was the CPWL and the other gun charges. The hate crime statute here is completely different. The racial bias element we're talking about discusses motive, goes to motive, and motive is always relevant. And it had everything to do with the assault crimes that were charged. Having said that, Edie found that the trial court erred in allowing evidence of the OCDR or the defense release status. So to do that, it had to have found that the OCDR provision was a sentencing factor. It did not create a separate offense. It did not fall within Apprendi's exception.
Why did it have to do that? I thought if you take Edie on its terms, it seems to have the following mode of reasoning, which is if Apprendi gives a defendant a right to have the jury decide an issue, and the defendant doesn't, even if Apprendi does that, if the defendant doesn't want the jury to hear it, then the defendant can forego that right. So why did Edie have to rest on the idea that actually Apprendi didn't confer a right to have the jury decide the question?
Well, Your Honor, I would say if that is the holding of Edie, then it's wrong. It goes against Blakely, and I know appellant relies on Blakely for the premise that the defendant can waive his right to a jury trial on a certain element, can take that from the consideration of the jury. But if you look at Blakely, and this is at page 310 and footnote 12, the court says, and the court is responding to the dissent, even a defendant who stands trial may consent to judicial fact-finding as to sentence enhancements, which may well be in his interest if relevant evidence would prejudice him at trial. But then the court recognizes and goes on to say in the footnote 12 that states are not required to give defendants the option of waiving jury trial on some elements, but not others. And I think what that shows is, sure, appellant has a right to waive his jury trial on certain elements, but that doesn't mean that states have to accept that waiver, nor do trial courts have to accept that waiver. I think appellant thinks that because a Sixth Amendment right to a jury trial is something that he can waive, then he gets unilateral power to decide how the trial will be conducted. And that's simply not consistent with the case law. I mean, Goodall specifically
In
says,
Edie,
I'm sorry?
in Edie, I mean, it's not just appellant's argument. In Edie, this court gave the defendant the power to take the OCDR issue away from the jury. But
Edie was very clear that the OCDR issue was relevant only to sentencing. It had absolutely no, and the government agreed. The fact of defendant's status.
Question: Is it your position that OCDR, that Apprendi actually doesn't give a defendant a right to have the jury decide OCDR, that it falls within the Almendarez-Torres exception for criminal history, or is it your position that OCDR, Apprendi does give defendants a right to have the jury decide OCDR?
I think if you look at the strict language of Apprendi, I mean, it seems to be a pretty bright line rule. Other than the fact of a prior felony conviction, any fact that increases or aggregates the punishment creates a separate offense. And that's not the exact word, but that's the implication of Apprendi. If you look at the strict language of Apprendi and the rule of Apprendi, OCDR does not fall within it.
So,
however.
Okay, I was going to say.
I'm not saying it's the government's position. I think this court has not taken a position or purported not to take a position, although the implication of Edie seems to be OCDR is a lot more like a prior felony conviction than creating a separate criminal offense. And the court actually says that in Edie. I mean, that it says it doesn't create a separate provision.
Understood.
It's a sentencing enhancement relevant only to sentencing. So it's more like prior felony.
I'm not sure I got out of that the government's position about whether OCDR does or does not, whether Apprendi does or does not confer a constitutional right to have the jury decide OCDR.
I think Apprendi does. If you're looking straight at Apprendi and Elaine, I think the implication of those holdings have to be the OCDR has to be proven, creates a separate criminal offense, and has to be proven to the jury.
And that's the government's position. And that's the government's position. I'm not sure, because I'm not going to say that's a government position, because I don't think that's teed up in this case. The reason I think it is because you're distinguishing Edie by saying Edie was really a case where it rests implicitly on a holding that Apprendi does not confer a constitutional right to have the jury decide OCDR. And in figuring out whether to read Edie that way, it seems to me quite relevant whether, if we read Edie that way, Edie would be correct or would be relying on an incorrect principle of law. And so I'm not asking for, just out of idle curiosity. It seems to me quite relevant to the grounds on which you're suggesting we should distinguish Edie. If you're telling us, you should read Edie as implicitly holding something that our position is incorrect, that seems like not a very appetizing way of reading Edie. So I'm interested in trying to figure out whether you think the way you're distinguishing Edie rests on a mistake of law or is correct, that actually OCDR is more like criminal history and falls under Almendarez-Torres. And I also ask because I know that the Department of Justice has, at times at least, taken the view that the federal equivalent statute is covered by the Almendarez-Torres exception. And there's some federal support for that. And think federal courts are deciding, I'm not up to date on that, but I think federal courts used to be, some federal courts had accepted that and some may not have. So it seems to me it's an important and interesting question that is quite relevant to how we should read Edie, whether your view is that if Edie implicitly rests on the idea that Apprendi doesn't give a defendant a jury trial right on OCDR, that's a correct principle of law that Edie adopted implicitly, or whether if Edie adopted that implicitly, that's an incorrect principle of constitutional law.
Your Honor, I understand, but I think at the end of the day, OCDR is just a very different kind of sentencing enhancement or statute than the hate crime statute here, because it really is relevant only to sentencing. And even if the court.
Why is it really only relevant to sentencing? I mean, suppose you have a statute that says if you have a prior felony conviction, you cannot carry a weapon, firearm. And you could just as easily say, well, we found this man in possession of a firearm. Now, his past history of what he had done in the past is not relevant to this offense. It's only relevant to sentencing. And how is that different from saying we found this person in possession of a firearm and he was on pretrial release? He was charged with another crime. And we have a statute that says when you're on pretrial release charged with another crime, you can't carry a weapon. Why are those two things different?
I think for the charges in Edie, the carrying a pistol without a license, the fact that he was on pretrial release for another crime when he committed the charge CPWL doesn't relate to the elements of the CPWL charge that he is charged with. The DC hate crime statute, however, criminalizes the defendant's motive for why he conducted a criminal act, here assault. And that motive would be relevant regardless for the assault charge, underlying assault charges anyway.
I guess where I lose you in that answer is when you say that OCDR is not relevant to the elements of the offense, or the prior conviction is not relevant to the elements of the offense. If Apprendi says that as a matter of constitutional law, because the legislature made that circumstance affect sentencing, it has to be treated as an element. And that's what I thought your argument is about what these things turn into under Apprendi. Then it's not only that it's relevant, it becomes under Apprendi one of the elements of the offense. So it is,
yes,
it's
not
relevant to an element, it is an element.
And I agree with that. And I think the problem with Edie is that it says we don't need to address that issue because the stipulation resolves the Apprendi issue. And I just don't think a stipulation, it's not a waiver. The stipulation to the fact that he was on release at the time he committed the offense doesn't resolve the Apprendi issue. So the Edie is a difficult opinion because it purports to not address an issue, but when the only way it can get to the holding it does is by resolving the issue. And I would just point to the language in Elaine, which it says, as noted, the essential Sixth Amendment inquiry, and in the context here, I'm speaking, paraphrasing, in the context of Apprendi, is whether a fact is an element of the crime. When a finding of fact alters a legally prescribed punishment so as to aggravate it, the fact necessarily forms a constituent part of a new offense and must be submitted to the jury. So, I mean, Edie purports to not have to resolve Apprendi, but the whole basis of Apprendi is you have to determine whether it's an element or a sentencing factor. And
I thought what determines that is whether, I thought what determines whether the answer to that question under Apprendi is whether the fact and issue results in or can result in an enhancement of the sentence, of a greater sentence. If it can, I mean, that's why I gave you the felon in possession hypothetical. Am I mistaken? A felon in possession is a crime, and the jury has to hear that the prior felony conviction of the defendant and has to find that the defendant had a prior felony conviction. Am I wrong about that?
No,
If
you're
that's
absolutely
true,
correct, Your Honor.
if that's true, then I frankly can't understand what the distinction is between that and requiring the jury to find that the defendant was on release, for example.
Well, Your Honor, I think for me, your question is, you have felon in possession, and an essential element of that is a prior felony conviction. You also have charges that are CPWL, for instance, or possessing a firearm, and then there's a separate sentencing enhancement that is based on a prior felony conviction, like a different portion of a statute in the sentencing provision increases the sentence for a possession of a firearm charge if you have a prior felony conviction. I think
Well, I
Apprendi says,
understand what Apprendi has carved out, but when the
Yes.
statute, so your argument basically is what Judge McLeese said. We should have said in Eady is that although the Supreme Court in Apprendi only talked about prior convictions, this business of being charged with an offense is so closely analogous to a prior conviction that it should be treated the same way. But we didn't say that, actually.
no, you didn't. And I think that seems to me the logical implication of Eady, because I don't see how the court could have reached the decision it did without deciding the Apprendi issue.
Well, why couldn't it have said, why couldn't it have been thinking more like what it said, which is, this is a right that arises out of Apprendi, and we're going to say that when defendants have rights to jury trials arising out of the Apprendi, if they want to forego, they can.
And Mr. Casey, the government's not disagreeing that he has a right to waive it if he wants. But the point is, the trial court does not have to require or accept that waiver, and nor does the government have to accept.
Well, no, but in Eady, we thought the trial court did have to accept that, and so
yes, and reasoning.
And the point is, I guess, to me, it seems like, do you think if we read Eady to say, Apprendi created a right to have the jury decide this, the defendant said he wanted to forego it, the court was required to allow the defendant to do so. Your point is, well, that we shouldn't read Eady that way because that would be inconsistent with a bunch of other case law. If I understand your point, that's really, the gist of one of your lines of thinking. And I get that, I see that point, but I struggle with that because the other reading, you say, no, read Eady a different way. Read Eady as implicitly saying that actually the defendant has no right under Apprendi, and so the jury should never heard any of this. But the problem with that is that if your view, which we don't know yet because we don't know the government's position on this, but if your view is that would also be a mistake of law, then I'm not sure why we should read Eady as implicitly making one mistake of law rather than explicitly making what you think is a different mistake of law. I mean, it seems like either way, you just think Eady is incorrectly decided. And the issue is, which mistake do you think it made?
But I think the point for this case here is, regardless of whether Eady is incorrectly decided or not, and Eady is just distinguished. Eady and Williams are just distinguishable because they involve a different enhancement, OCDR. By enhancement, I'm just using the term generally as a provision that increases the sentence of another offense. So in that sense, OCDR is similar to the hate crime statute. But OCDR is just, the release status is certainly, as Judge Glickman noted, it's more similar to the exception in Apprendi for a prior felony conviction. And that's how you can distinguish Eady from this case, because Apprendi
Can I ask
makes
a further
clear,
question on that? I know you're sick and tired of hearing about Eady, but in discussing Eady, and I find my memory failing me at certain points about the case. But is it possible to think of the case this way? In Eady, what the government wanted to do in order to prove the sentencing enhancement was to prove not simply that the person was, that the defendant was on release status, but a little bit more that technically it didn't have to prove. Namely, it wanted to make that proof by showing what the defendant was on release status for, what the actual crime was. Am I remembering this correctly, or am I confusing it with another case?
I
And-
don't,
And so one can argue that what Edie is really saying is, look, the government's entitled to prove release status, but they're certainly not entitled to prove more about the offense for which the defendant is on release, and where the defendant and where the government's where the alternatives are teed up as you can have a stipulation that he's on release status, or the government can prove more than that, and the more than that is prejudicial, and it doesn't need to. Then the defendant has a right to limit the government's proof. And if the government had come in and said, "Well, we'll do it another way without it," that would have been different. But they didn't do that. Am I unfortunately completely fantasizing what I remember Edie was about?
Your Honor, my recollection of Ede, that sounds more like the facts of Old Chief and the stipulation for the prior felony conviction.
Yeah.
That the government wanted to bring in the judgment of conviction and include the name and nature of the charge and not accept the stipulation. I don't think that's what happened in Edie. Edie, there's a stipulation as to the defendant's release status, and it was presented to the jury. And the court, Edie, basically said the stipulation resolved any Sixth Amendment Apprendi issue. And it was therefore error for the trial court to allow the stipulation to be presented to the jury. That's my recollection
Okay.
of Edie. And I've read Edie several times, and quite frankly, sometimes, I can't keep it straight in my head as well. But I think for purposes of this case, one thing Edie does make clear is that OCDR, like prior felony conviction, really has only relevance to sentencing. It has no bearing on the elements of CPWL or any of the other possessory gun offenses that were charged.
Can I ask you
That is not
another possible way of distinguishing the OCDR and prior criminal history issues in Edie and Williams from our case? And in particular, I guess as a prologue to that, do you have a view about whether independent of and prior to Apprendi, the determination as to bias-related crime was intended by the legislature to have been decided by a jury or a judge?
No, Your Honor, I have not looked into that. But my understanding of Apprendi is the Supreme Court doesn't seem to care about the legislative intent. They're applying this rule that if it increases the fact of punishment and other than a prior felony conviction, then it has to be considered a separate criminal offense. And the reason why I say that is that in Apprendi, the New Jersey hate crime statute specifically set out a sentencing scheme that specifically said the trial judge will hear evidence as to the bias, the hate crime offense, the prejudice, or the motivation, and then it'll make a finding by a preponderance of the evidence, and then you can increase the sentence by, I can't recall the amount. And they struck down that provision, and clearly it was in a separate sentencing position, portion of the statute. And the court basically said it doesn't matter what the legislature intended. It doesn't matter. We're not going to do formalistic approaches to this. It doesn't matter whether it's a separate sentencing statute or it's with the offense itself. Just any fact that increases or aggravates punishment is a separate offense.
For sure, I get that. Apprendi trumps contrary legislative intent.
Yes.
I get that.
Yes.
The question is sort of the flip of that, which is like for felon in possession, for example, leave aside Second Amendment problems, theoretically, the legislature could have said, look, it's a crime to carry a gun, and it'll be a sentencing enhancement for the jury for the judge to determine its sentencing if the defendant has a prior criminal history of some kind. That's sort of how the way the CPWO enhancement works. And Apprendi would tell you, if the legislature wants the judge to find that at sentencing, that's fine. But sometimes legislatures choose not to do what Apprendi would have let them do. And instead, the legislature, of its own intent, says, we're going to make this something that the jury is going to have to find. Even if we could have done it differently. And I'm trying to figure out whether you think the bias-related crime is an offense that, independent of Apprendi, the legislature said, we want the jury to decide this question. It's going to be an element of the crime. It creates an aggravated crime that cuts across a lot of different provisions. So we put it in a separate provision of law rather than, in dozens of different provisions that it aggravates, or maybe more than dozens. And I'm just trying to figure out, and it sounds like you haven't looked into the question, you don't have a view about whether, independent of Apprendi, the bias-related nature of the crime is something that the legislature intended would be an element all along. Am I right that you don't have a view on that because you haven't really looked into that topic?
That's correct, Your Honor. I do not. We do
And
not
the
consider it.
reason I asked that question is because we made a point in Edie of saying OCDR was intended to be a sentencing enhancement. The legislature wanted the jury not to hear about it and wanted it to have to arise only at sentencing. And now Apprendi may or may not change that, we said, and we don't have to decide that, we said. But it's a possible difference between Edie and the prior criminal history provisions that were also at issue in Edie and Williams, and the bias-related aspect of this crime, if the legislature all along intended that the jury decide this question independent of Apprendi, so that the defendant's right, and maybe the United States' right to have a jury trial, is not derived solely from Apprendi, as it seems to have been only in, or either doesn't exist at all, as seems to be the case with the prior criminal history enhancements at issue in Edie and Williams, and may or may not have been, arisen from Apprendi as to the OCDR provisions. But so that was the reason I'm asking the question. But the bottom line is you don't have a view about whether prior to Apprendi or independent of Apprendi, the legislature intended that this aggravating circumstance be found by the jury rather than determined at the time of sentencing by the judge.
That's correct, Your Honor.
Oh, go ahead. I'll let you answer that.
Oh, I answered.
Okay.
I said that's correct, Your Honor.
I just didn't want to interrupt you if you were going to elaborate, but I have a question about another. We've kept you up here way past your time, but another of Mr. Ocasey's arguments, which is, do you agree that the trial judge viewed herself as like precluded from, using limitations upon the N-word and well, I'll let you answer that first. Do you agree with his characterization of that?
No, I think the judge well understood that it had the discretion to sanitize, and it just didn't think it was warranted in the circumstance. And I say that because the portion that Mr. Ocasey, or the transcript Mr. Ocasey read, the court went on to say, look, if you take the N-word references out, it changes the tenor or the color or the complexion of the entire case. And the government gave an example, and which the court agreed with, which is when appellant rode his bicycle past the victim who was parked in the PNC Bank parking lot, he said, "Are you going to call the cops?" and then N-word. And if you take the N-word out, the "are you going to call the cops" does not on its face sound very threatening or hostile. The moment you put in the N-word, it changes the entire nature of that statement and how the jury might interpret it or use it to find support for the elements of the offense.
Well, then is it the case that the judge never ruled on his request to, sanitize it in a way other than just exclude it altogether?
No, Your Honor. I think the court said, she specifically said, I thought the court ruled that she did not believe that a sanitization was necessary, that it was the facts of the case that the witnesses were going to testify to. It was a story that the government wanted to tell, and it was necessary, and the appellant wasn't entitled to get it cleaned up. My understanding is that she denied his requests he filed a motion to keep the N-word evidence from the jury, and she denied that request, and she ruled that it should be admitted. And from my understanding of the transcript, she understood she had the discretion to clean it up. I think appellant did not in my recollection of the record, and I'd have to look at it more carefully, is as to his specific argument about the repeated references to limit the numbers in closing arguments. I know he certainly wanted the court generally to keep as much of the racial slurs out of evidence as possible, but there was not that specific argument made to my recollection. But generally, yes, Mr. Ocasey did want to keep that word out as much as possible. The court didn't ruled, I think, that she wasn't required to and it wasn't necessary to, and she shouldn't, because the jury had full right to hear the entire story. And I think that was the gist of her, or the entire narrative of the government's case. And that was the gist of her ruling.
If she had ruled the other way, do you think that would have been wrong? Like if she started saying, okay, prosecutor, you know, just like Mr. Ocasey said, even in child porn cases, judges might limit the number of relevant images or something because it just is too inflammatory.
Sure. And well, if you look at this record, I mean, racial bias was an element of the offense for the hate crimes statute. So the government had to present evidence and prove it. Given that, I think if you look at the entirety of the case, I don't think the prosecutor was sitting there trying to put the N-word in at every juncture he could. I mean, it was a part of the case, but there was certainly a lot of discussion and closing arguments about self-defense and the witness's testimony about how appellant never made a threatening gesture towards the defendant. So I don't agree with Mr. Ocasey's characterization of the record as the prosecutor gratuitously throwing that word around to inflame the passions of the jury. And at the end of the day, as Your Honor noted, the jury ultimately did not reach a verdict as to the hate crime charges. So if appellant is right that the use of this word was so inflammatory and the government used it so many times and threw it all around, you would think that the jury would convict on the hate crime charges and the destruction of property because their passions were so inflamed, but that's not the case. The verdict reveals that the jury carefully looked at the evidence. They couldn't reach a verdict on the hate crime charges, and they found him not guilty of the destruction of property, which made sense because the evidence as to whether the car was damaged or not was a little bit shaky. So at the end of the day, any error in putting this evidence before the jury was harmless under any standard. First, because as the government argued, all this evidence was independently admissible. Even without the sentencing enhancement, evidence of motive is always relevant. And this showed appellant's racial animus and his motive for attacking the victim. Secondly, the jury's verdict shows that what Mr. Ocasey feared or what appellant feared did not pan out. The jury's passions were not so inflamed that they couldn't look at the evidence carefully. And third, the evidence of guilt was overwhelming. The victim's account was corroborated by two neutral eyewitnesses who said appellant was the initial aggressor and the victim did nothing to fight back. Given all this, any error would have been harmless in any event. And I think there are no other points I wanted to make, but if there are no further questions, we'll submit on our briefs as to the second and third issue, the cross-examination and jury instruction issue, and ask that the court affirm the judgment of the Superior Court. Thank you, Your Honors.
Thank you. Mr. Ocasey, you have a few minutes in rebuttal.
Thank you, Your Honor. Just to point out, on June 5th, 2019, the defense filed a reply. This was to try to keep the evidence from the jury, or at least to mitigate it. And in the reply, there's a request on asking for a strong limiting instruction if the N-word comes in. The first request was to keep it out under 401, 403, or analog Johnson. The second one was to limit it with a strong limiting instruction if it were to come in, which could have been something like happened in Williams, which is after you hear the word, here's what the word's being used for. It's not being used for other purposes or to characterize him or whatever. It's being used for this particular reason. So that
point about the limiting instruction. I guess I have two questions. One is I don't remember the absence of a limiting instruction being a point raised in your briefs. Did I miss that?
I'm not sure if I specifically said limiting instruction, Your Honor. I know I said we talked about sanitizing it and there are many ways to do that, but once it's taken off the table and we're not given the option to do it, there are no more abilities, there are no more options available. So the Judge Knowles was not allowing it. So these other options that I'm telling Your Honor about were mentioned to her before. She rejected all of it out of hand because she thought she couldn't do it, and therefore.
That leads into my second question, which is, is there a ruling from the trial court on the request for a limiting instruction? And relatedly, when you got to the time to instruct the jury, was there a specific reminder to the judge, by the way, or when the first time the word came out, was there a reminder to the judge, I've made this request, that there be some kind of a cautionary or limiting instruction?
No, Your Honor, but in defense of our position, there was so much pretrial litigation about this issue. And that was oral and also in writing, and we are totally rebuffed about it. So as the court knows, we're not obligated to ask a fourth or fifth time when the court says no to something. We have to respect the judge's decision.
Yeah, and you say totally rebuffed, but you haven't. I don't think my question's compound, but there's a half of it that we haven't drilled right into, which is, did the judge at any point say, no, I'm not inclined to give a cautionary instruction?
Not in those exact words, Your Honor, but she did say what I read to Your Honor, saying she's not going to sanitize it and that it's going to go to the jury. When I asked about
those seem quite different from, I'm going to let the evidence come in all of its detail, and I'm going to let the jury decide it. That seems quite unrelated to, okay, but at least give an instruction that tells the jury, make proper use of it, don't make improper use of it. That seems like a different topic.
Well, Your Honor, if the court would just, again, I'll just defer to the transcript on June 11th. I make a statement here about not wanting the judge to do something to help not allow it to be the central issue of the case, and the judge comes back and says, I don't think that's for the court to cut that out or sanitize it because it's for the jury. So I think that looking at that paragraph, when the judge explained that, she never offered to do anything that we asked for, so it was rejected. If not directly, implicitly, because all of the requests to ask for some kind of limit we're told no. And that, if I can just pivot to the next point I want to briefly make, Your Honor, which is about the basis for the government's arguments now. At the trial court level, the government was very insistent, and the court can review the pleadings, that Apprendi gave them a right or duty to admit all this evidence and to prove it at trial. Now they're trying to back away from that, essentially, here before the court, and they're seeming as though Apprendi gives them the duty to do it, and the government can ask, the defense can try to waive it, but the court somehow has the ability to just reject a waiver without any real basis or without an explanation. So essentially, that's not the basis of what they asked for in the trial court. They led the court to believe, and they took the position below, that Apprendi gave them the absolute right to prove this to the jury. Now, I think that at this point, any deviation from it that's substantial, that the court should look at that with some serious, with a jaundiced eye, because they're really trying to move the ball a little bit as far as what their position was before. In addition, Your Honor, when it comes to the other issues I want to just briefly touch upon is the admission of the N-word, the December incident of the N-word, which Judge Knowles, prior to trial, did say that she ruled that was not going to come in to evidence. She found it to be inappropriate, the December 2018 statement. And during the trial, it was brought up. Essentially, the argument was that we opened the door, although we were never put on notice about that. There's never analysis under the curative admissibility rule or doctrine. It was just, you said this, it comes in, and despite the nuances that existed there, they were brushed under the rug, and we weren't allowed to actually explain why that wasn't admissible and why it shouldn't be admitted. That further.
Why was it wrong to admit that? The trial court's view was your client testified on direct, essentially, is paraphrasing. I didn't tell the truth previously when I was talking to the police and others about whether I used the N-word or not in this incident. And the reason I didn't tell the truth, I didn't admit it, was because I was, ashamed of having done it. So that was the direct testimony. And the prosecutor's argument is, I'd like to cross Mr. Smith to suggest that that's not true, that he's saying now that he's ashamed of having said it. But it's not true that he's ashamed. He said it because he, at least when he gets mad, he has racial bias that manifests itself. And I'm going to try to, again, just the prosecutor's line of thinking paraphrased is what I want to suggest to the jury is that he says now he's ashamed of having done it. But if you want to try to figure out whether to believe that claim, you might want to know that in another similar incident, he got into a bicycle car controversy and he used the same words. So the prosecutor would try to argue, I submit to you that you shouldn't believe him when he says he's ashamed. What you should believe instead is that he has racial bias that comes out in sentence like this. And the trial court basically said, and you pointed out quite fairly that the later incident doesn't definitively show that he's not ashamed or that his explanation for not having admitted it is untrue. I think that's a fair point. But the trial court's take on it, paraphrased, is, well, yeah, I can see, people could argue both sides about whether that undermines his credibility. And I think it's fair to allow the jury to hear it and figure out whether they think the second incident means that your client wasn't telling the truth when he claimed that the reason he'd, not told the truth earlier and the like is that he was ashamed of having done something. It's a discretionary ruling by the trial court. And why is that not kind of a reasonable discretionary call?
Well, Your Honor, to just start off, the trial court did initially find that evidence was going to be irrelevant and not admissible during the trial. So essentially, the question was, did Mr. Smith's testimony allow the government to then cross him on that? The government's position in before the court on their brief is that the curative admissibility doctrine does not apply. It's just basic cross-examination on an issue. But they're cross-examining with otherwise inadmissible evidence. This is evidence that was excluded from the very beginning. So in our position is for them to be able to use that, they have to proceed under the curative admissibility doctrine, which they waived for this court. And that would
be right conceptually. I mean, if a trial judge says ahead of trial, based on my understanding what the evidence is going to be, this is irrelevant information. And then during the trial, some things come in that nobody foresaw. And the party says, well, in light of this other evidence that came in, we're not saying it came in improperly. It was itself relevant evidence and it came in, but now that it's in, something that, the trial judge originally thought was irrelevant now is relevant. That seems like, that's standard fare. And why could that be admissible only if, as I think you were suggesting in your brief at least, if the new evidence that kind of changes the picture itself was improperly, should never have been admitted, which is kind of what prerequisite for the curative admissibility doctrine.
Well, Your Honor, in Romero, which was decided last week, and Your Honor was one of the authors or joined the opinion. I'm not sure who authored it, but Judge Blickman and Your Honor both were deciding that opinion. The defendant said, I would never do something like that, which in of itself may not be seen as otherwise in irrelevant evidence, but it was analyzed under the curative admissibility doctrine. That's what the analysis proceeded under that doctrine, and rightfully so, because it was evidence that led to the government then getting into the back.
Did we hold in Romero that the original testimony of the defendant was itself improper?
I don't think it explicitly said that, but the court analyzed under the curative admissibility doctrine.
And did we imply it in some way?
I think so, Your Honor, because if that weren't the case, the court could have dismissed with the case, dispersed the case in one opinion, one page, saying that it was proper impeachment. He testified it was the light was yellow. They said the light was red. He was impeached, and that'd be the end of the case. It was more there because it had to do with some really prejudicial evidence, which was the defendant's prior conviction that was going to prejudice the jury. And even then, Judge McKenna, when the case was affirmed, she actually sanitized it by ensuring that the evidence was only admitted in a certain way, by curtailing what the government could do when they admitted it, and by making sure they didn't stress it, which is not what happened here. The N-word was stressed all over the place. And this is just one more example of Mr. Smith is a racist because he uses the N-word all the time. And that doesn't even get into whether or not she should have allowed it to happen, meaning the facts of whether or not the words were the kind of words that would elicit that type of statement. But we believe that the curative admissibility doctrine is the way to analyze this particular claim because of the nature of the prejudice that ensued based on the ruling that the court made, and it really disadvantaged us greatly. So that's our position, Your Honor. And I think the last thing I just briefly say, if I could just have the court's indulgence, is if there are any questions about the jury instruction, I want to be clear that we did ask for interference after we were told that trespass was confusing, we asked for interference, and we were given for the defense of property instruction, misuse or taking. But Mr. Pajo was not really taking the bike. He was holding onto the bike, and he wasn't really using it. He wasn't riding it around. So essentially, we had a situation where if the jury read those words the way that they are commonly understood, they would have thought that he has no defensive property right, because the word interference, which is in Gatlin and in Sheehan and other case law, and trespass was excluded for no reason. There was no reason that the judge gave for that. It just happened because she just didn't want to do it. So that's another error we think also affected the outcome of the case. And with that, I would submit the case unless there are further questions.
Counsel, thank you both very much. The case is now submitted and you may log off.
Thank you, Your Honor.
Thank you.
We'll call the second case on the calendar, John Uhar, I hope I'm pronouncing that name correctly, versus District of Columbia Alcohol Beverage Control Board. On the calendar, John Uhar, I hope I'm pronouncing that name correctly, versus District of Columbia Alcohol Beverage Control Board.
That is correct. I don't see my video though. This is Jackie Meyer. Does anyone see me?
No, we do not see your video. Now
Okay.
we see it.
Sorry about that. Technical difficulties.
That's okay.
Okay. Good morning. May it please the court. My name is Jackie Meyer, counsel for the petitioner, John G. Uhar. Mhm. Okay. Your Honors, I'd like to reserve 3 minutes for rebuttal. There are 2 decisions I seek and 3 issues I would like to highlight for the court. The first decision is the court should reverse the order number 2020-81 of the ABC board, and for 3 related reasons. And the second decision is on a motion that was referred. The court should grant petitioner's motion to supplement the record. First, the court should reverse the order of the ABC board because the board committed errors of law. So under a de novo review, the court should overturn the board's decision. Second, the court should reverse the order on account of the unfair administration of justice. And third, the court should reverse the order because of the lack of due process granted petitioner. And in more detail, the first reason the court should reverse the order is the errors of law. These are detailed in petitioner's brief, but for example, regarding statutory requirements that the board did not meet, such as provision of an employee who would assist the protestant, that's Title 25, section 25-209, additionally 25-201C6, 25-315B, which is a check sheet. 201C6 is conducting an investigation to identify violations of the governing statute. But most importantly, at issue in this petition is the good character provision, which is 25-301A. All of this is detailed in the petitioner's brief, but there are 2 errors of law in the respondents or in the board's order, which in particular, I'd like to discuss and bring to your attention. The ruling, first of all, the board ruled contrary to the statute, 25-301A, which is the good character provision, and contrary to precedent, Haight versus the DC ABC board, which was a decision from this court in 1981, and rejected consideration of evidence of illegalities short of conviction, which this court said in Haight that it could consider, and which the statute allows by its language. The board order, paragraph 20, which is at the joint appendix, page 290, is a clear error of law because the statement, the Protestant's argument in favor of considering offenses not leading to a conviction when making a character determination runs contrary to the applicant's right to a presumption of innocence. Such an invocation is a clear demonstration of the board's edict not to consider offenses not leading to a conviction, but the board's statement contradicts the statute. Section 25301A1 does contemplate character evidence short of conviction because of the existence of the separate clauses 301A3 and A3A and A4, which reference conviction of felonies and misdemeanors. So it is clear that Section 301 does allow the board to consider illegality short of a conviction of a felony or a misdemeanor because of the separate provisions which specify those. And a second error of law.
Can I ask you about whether that alleged error of law is load-bearing or not? Because your opponent argues that in the same paragraph earlier on, the board had said, even accepting your client's allegations, the violations, whether considered independently or together, just aren't so serious or egregious that they would cause the board to deny the license application. Do you agree, first of all, do you agree that that is sort of an independent ground that covers the whole waterfront of these allegations of, don't grant this license renewal application because the applicant has, done a bunch of bad things in these various, in trying to get various approvals and permits? Do you agree that that is that covers the whole waterfront, or do you think it does not?
I apologize. I don't know exactly what you mean by waterfront.
Sorry, I didn't mean to speak figuratively. I guess your client made a number of allegations that all fit into the general description of don't grant license renewal because the applicant has done a bunch of bad things. He got permits he wasn't entitled to. He committed fraud relating to things he said in connection with all of that. And I'm just wondering whether you think that this ruling by the board covers all of those allegations that it was intended to cover, and covers all of those allegations, and says, look, even if what Mr. Uhar is saying is true, they're just not serious enough to lead us to deny. And my question is, do they cover all of your clients? Is this a ruling that is intended to express an opinion about all of your clients' allegations of that kind?
No, I don't believe that the board did cover it all. And I think that that is one error and one reason why it should be remanded for further consideration. I think they did mention 25-315 at the end of their order, and they mentioned that the minor statutory or regulatory violations were not enough, but that's a separate category. Those are the violations under the actual liquor control laws, such as serving to minors or not having a manager on the premises and that sort of thing. And I think
the sentence you're referring to about minor violations of the alcohol laws, that's in the paragraph, but there's an earlier sentence that says the protestant alleged various prior violations of the district's fire, construction, health, and public space rules. And then the sentence that says, even if those allegations, I'm reading that word in, are true, the board is persuaded that they're a ground for denial of the application. So they're clearly addressing more than just the alleged violations of the rules relating directly to how to operate the laws governing, the alcohol laws, as the board was referring to.
I don't believe that they did conduct a fair analysis. And that's one of my next points, is that there was an unfair administration of justice, whether you even considered a due process violation or equal protection of the laws. I was going to bring to your honor's attention, not a decision, so I'm not sure if you would like me to write a 28K letter or not. It's a decision of the board, but it's not a decision of the court. So in the matter of Mayar LLC trading as Charcoal Town, which was order number 2021-260 of the ABC board it was decided in June of 2021. So since petitioner, submitted his brief, but it shows that there's been an unfair administration of justice, and perhaps Il-Canali just gets a different treatment. And I don't believe that the board did consider the litany of violations in the same manner when some of the same circumstances applied for Il-Canali. And just down the street, the restaurant Charcoal Town, which was denied its liquor license and was closed. I don't know if it was shut down, but it was closed. In that case, it was a Middle Eastern shawarma restaurant and lounge just about a block away from Il-Canali in Georgetown. And it would, in that case, the board acted inconsistently by considering the applicant's illegalities, some of which were the same. The two that they focused on, one of which was the supervision requirement of having a manager on the premises. And in Il-Canali, there were two similar violations. And in addition, more notably, the Charcoal Town expanded into the next door property and sold alcohol there without a license. And similarly, Il-Canali has been expanding, whether onto the sidewalk, onto summer gardens, alleys, sheds, second floors, and that's a lot of what they've been doing over the years.
Ms. Meyer, I'm sorry, I'm not sure whether you're trying to introduce sort of a new issue of inconsistent treatment or something, but the case may be instructive for other reasons. But while you were talking about it, and the due process issue, you keep mentioning they didn't consider, and yet I think in your brief you actually asked for a remand with instructions to deny the application. Is that what follows from your view of what went wrong here, or is it that or is a remand for reconsideration of all the things that they didn't consider make more sense?
I think that we argue in the alternative. Reversal is the goal, with remand to deny the license or to restrict it. The board does have authority to issue a license with restrictions under various cases, and the board can issue the license with the premises for the premises only as permitted, and that would be 1063 property, first and second floor, and 1065 just the first floor, with no sidewalk garden, sidewalk cafe, because there are different outcomes, whether denying the entire license or just restricting it to the areas that were permitted.
I guess, the status quo is that there was all this evidence that wasn't considered, and people who didn't testify, and evidence that wasn't considered. I was just wondering how you get from that to assuming all that evidence would have made them decide to deny the application.
Well, there is a statutory requirement for an investigation. And as we did claim in our brief, this wasn't fully investigated or wasn't adequately investigated. And I can't predict the future, and I can't say what the board would do if they did conduct another hearing, but that doesn't mean that the petitioner isn't entitled to.
You agree that further proceedings would be needed?
I believe so. I like to think that with further proceedings that the board would accept all our arguments and see the light and look at the statutes and the precedent. But as I said, I can't predict the future, but certainly it's a very significant dereliction of duty not to allow the subpoenas that petitioner, requested, and not to, fully investigate. I believe that was a specific due process violation. And it wasn't just that, it was a statutory violation that would be another error of law, because the statute does call for the community resource officer to provide assistance. And I think that the respondent's brief did not, adequately respond to that. Basically, the respondent said because the petitioner did not ask for help listing witnesses on his information form, then ABRA satisfied its statutory obligations. And I don't believe that they did satisfy their statutory
Well, I think
obligations.
it's more than that. I thought that the argument that your opponent was making was there was someone assigned help and their help was given. And in fact, there were oral meetings at which your client was specifically orally informed. If you want to call witnesses, you got to put them on a list. And
Yes.
the client didn't do that. And I think that the rest of it, your opponent's position is your client's argument seems roughly to be, well, I kind of got confused because I had a conversation with somebody about subpoenas and I asked about whether I had to serve those subpoenas on my opponent. And I was told accurately, no. And so I got confused and I thought that meant, this is by implication, but maybe your client is implying, well, I kind of got confused and I thought maybe that meant I didn't have to do what they previously told me about the list. And your opponent's argument, at which the board, I think in substance seems to have agreed with, is that's just not that's not a reasonable misunderstanding. That's not that doesn't make sense. Your client was given specific advice about a thing to do. There was a discussion about a different thing, and it wouldn't be reasonable to think that discussion would excuse doing the specific thing your client was told to do. I think that's taken together. I thought that was sort of the response of your opponent. And do you think we should be deferring to the board's assessment of kind of the pros and cons of that, or do you think we review the board's determination to quash the subpoenas under those circumstances deferentially?
Well, while the court does defer to the agency in certain matters, including some matters like these, the agency does have wide latitude to include evidence, and agencies should resolve any doubts in favor of admitting the evidence. And that's under Haight and other precedent. And they did not resolve any doubts in favor of admitting the evidence. And if you look at the form that we were talking about, it doesn't actually say that you must list all witnesses, nor does it say that you can't add other witnesses later. So my client did put, I believe, a couple of witnesses down. I think he filled up about the block of space on the front page, while there is more space on the second page, but it does not actually say that you must list all witnesses. And, the respondent claims in its brief, well, he didn't ask, so we didn't have to tell him. But, that is the whole point of a community resource officer. And, petitioner is not a lawyer. And that is, the obligation of the community resource officer to assist. And, certainly no one ever said you must list all witnesses and that you will never be able to add any more later on. So, and I would like to bring up another error of law, if I may, which was also specifically from the board order. The board order, paragraph 19, where I believe the court should reverse the order because the board stated it could not make its own determinations of matters passed upon by other agencies when it was actually free to do so. So that's under both FTC versus Texaco, which I cited for this proposition, a DC Circuit case from 1977, and also Craig versus the ABC board, DC ABC board from this court in 1998. I think both petitioner and respondent relied on Craig. I believe FTC and Craig both support this proposition, even if they're not fully consistent. Under FTC, the board can review or override other agencies' actions, thus the error of law here.
Is that what you thought should happen? Is that are we talking about the DDOT action on the sidewalk? Is that?
There were different agencies. I apologize. I actually thought I unplugged my phone.
Barely hear it, so don't worry.
It must have a battery backup. There are different agencies that were considered. It was DDOT regarding the sidewalk. It was also the zoning board regarding the alley, and I believe also DCRA regarding the entire, you know, the bar and the entire restaurant. So it wasn't only DTOT.
But was it your client's goal to basically undermine the ultimate actions of those agencies?
No, I don't think so. And I think that's actually why Craig is instructive. I actually have a quote from Craig. The issue raised required the ABC board to review its own statute and any applicable regulations, not to determine whether the zoning board erred in issuing the certificate of occupancy. And I think that's the difference between what I believe the respondent posits petitioner is asking for and what he does request of the ABRA and the board. He's not asking for the board to cancel a certificate of occupancy or a permit from another agency, but to revoke a license to sell alcohol. And the board does have authority to do that and would be reviewing and acting upon its own statutes and regulations to do so, not coordinate agencies' actions.
So let me ask you just to make sure I understand what your position is. And to me, it was confusing in what was said in front of the board, and it's somewhat confusing in the briefs here. One argument would be those other agencies issued permits incorrectly. There was illegality in the outcome of those proceedings. And we want you to figure that out, DC, AB, CB. And in addition to figuring that out, we want you to end up concluding that happened enough so much that you should conclude that the applicant here lacks good character. That's one kind of an argument. And was that your argument, that these really at bottom, the lack of good character was reflected by the fact that the applicant got a bunch of permits that should never have been issued, and he did it by providing incorrect information and the like? Is that the gist of your theory to the board?
I believe that is essentially the gist. There were a lot of inaccuracies put on applications. Those were illegalities that were not, no one was convicted of, but that under precedent, the board should have considered.
And I guess what is tricky is that seems a little bit different than a point which would be, I'm not trying to challenge the issuance of any of these permits. Not only am I not trying to get them undone, it was clear your client wasn't trying to ask the board, the alcohol board, to start pulling permits from other agencies. It didn't have the authority to do that. And so it was clear your client wasn't asking for that. But you could have an argument that wasn't really about the outcome of any of those permit processes and said, look, I'm not taking a position. I'm not saying that the permit should not have issued. I'm just saying that there was, improper conduct that shows bad character. And do you think that was an aspect of your client's point, or was your client's point really wrapped up in showing that the permits were issued in error?
I think it's both of those. And in addition, my client wanted to use some of the evidence that was used for obtaining those permits to show, I think, the former of the two situations which you raised. A lot of the evidence that was used to get those permits, it's not just that it truly shows the bad character of the applicant, but it shows that there are just so many inconsistencies, and that the back to Judge Beckwith's question about the ultimate resolution, potentially reducing the size or footprint of the restaurant, because if you look at a lot of the submissions to the DDOT or the DCRA, like the DCRA, I believe the certificate of occupancy, you're supposed to have, the restaurant was supposed to have 6 bar seats, but it actually in reality has 12, at least at the time of the investigator's report, which is in the joint appendix. And
Ms. Meyer, I'm sorry, but as to the first one, that the agency did it wrong, basically, why doesn't that run smack into Craig?
That the board did it wrong?
That the agency, like,
or the other agencies.
Other agencies, sorry.
Other agencies. Well, I believe that under Craig, it it's not required to redo what the other agencies did, as long as the board acts with, according to its own statutes, which it can here, and it did in that case. The board has its own authority.
Two parts. One part is somewhat, at least in its general orientation, is favorable to your client. It suggests that the board ought to have considered something, even though it kind of connected or overlapped with something another agency should do. But the second part, I guess, part Roman numeral 4 of Craig, is a discussion that says, here is something that the objector wanted the board to consider and the board couldn't have considered. And that was Craig's argument that actually the liquor license should be denied because the applicant doesn't have a valid certificate of occupancy. And the court said, that's not, that's not something that could have been considered. And so I guess I think that I'm assuming that that's the part of Craig that Judge Beckwith was asking you, well, why isn't the point you're making now kind of collide with that part of Craig?
I agree, it does collide, but I still believe that something can be taken from Craig to support petitioner. And as for the part that collides, I would say overall, Craig can be distinguished. I mean, the facts of the case are distinguishable. The petitioners are distinguishable. The petitioners in that case had a vested monetary interest. They weren't the owner of the restaurant, as in a lot of these Abra cases. They were neighbors, but one of them had tried to buy the building that the restaurant was in, and another one, I think, had a commercial gripe. And so in this case, the petitioner doesn't actually have any vested interest, or rather any monetary interest in the outcome. So I think for the parts that do collide, I would just say that the case is somewhat distinguishable on the facts, and it is also an older case. But here, petitioner really is trying to put forth the interests of the district, the neighborhood, and not just his own personal interests. And I would even posit that he's putting forth a lot of the interests that the Office of the Attorney General should be supporting, rather than merely defending Abra. But petitioner doesn't have a monetary interest in the outcome of this case, as with so many of the other Abra or ABC board cases that this court has heard before and decided on. So this really is a unique case.
Great. We're a little bit over your time, but we will give you time for a rebuttal argument. Let us hear from counsel for the board.
Good morning, and may it please the court. Megan Browder on behalf of the District of Columbia Alcoholic Beverage Control Board. I'd like to begin with pick up where the court left off with petitioner about the court's statement that some sort of fraud could go to an applicant's character and fitness, but until the agency responsible for issuing the permit makes a final determination of illegality, or there's some sort of court order related to it, the board cannot review or override a coordinate agency's decision. That really follows directly from Koff and from Craig. And I would agree with petitioner that this case is not on all fours with Craig, but for a different reason. In Craig, the board did not have to override or review another agency's decision in order to assess whether the applicant met ABRA statutory requirements. Just a bit on the facts there. There was a restaurant and it had gotten an exception from DC zoning to be in a residential neighborhood. And then the board said that it was going to accept that exception and allow it to have an alcohol license. And this court said, no, the board does not have to defer to DC zoning's exception for the restaurant certificate of occupancy, because it has to make its own determination whether it meets ABRA's requirements. But what Mr. Uhar asked the board to do here, all of the determinations would have been overriding or reviewing a previous determination from another DC agent.
So is the question whether it's like necessarily whatever he's arguing would lead to the undoing of the permit or the agency action, or is it that it's, you know, it's openly his purpose? Because you can imagine a situation where he would want to, you know, or a protestant would want to, in support of, or, you know, in support of no good character, bad character, whatever, evidence that the person, you know, had committed criminal fraud or had done a bunch of bad things. And as Judge McLeese said before, don't care one way or the other what happens with that particular permit, but that's the context in which it happened. Is that within the scope of Craig as well?
I think it depends, Your Honor. I think what Your Honor said at the beginning of that question is true. It goes to whether it necessarily would undo the other board's determination. And I think it might be helpful for the court to think of it similar to a heck bar. You know, if it would necessarily invalidate the conviction, then you can't review it. It's similar here.
Let me ask you a hypothetical then to see what, imagine that what Mr. Uhar had said was, I'm opposing this application, and the reason I'm opposing this application is because I think the applicant lacks good character. And the reason I think the applicant lacks good character is because I have a video and also a live witness who's going to testify that the applicant bribed, you know, one of these permit issuers. And I want you to hear that, court. And I want you to, you know, hear that evidence and see that, watch that video and conclude that you shouldn't really be giving liquor licenses or renewing the liquor licenses of people who are out committing bribery of folks, of district officials. Is that something that you think the board would be required to consider?
Not specifically in the hypothetical that you posit. I think what the board would say is exactly what it said here. Go to the other agency, show them the evidence, and once they've made a decision on the permit, then come back to us with that. Now,
well, I'm assuming
there's
already been a permit issued. And imagine, just to clarify a little bit, imagine that the, you know, Mr. Uhar said, and I'm not really contesting the admission, you know, the permit that got issued, or maybe, you know, no permit was issued, or a permit was issued, but it was appropriate to issue. And it's just that there was this terrible conduct also. On the merits, permit should have been issued, but there was this terrible misconduct.
So I think if it wouldn't undermine the validity of the permit and it doesn't review the other agency's actions in reviewing the permit and issuing the permit, then the board could properly consider that. But
would be required to?
Yes.
Okay, can I ask you, and why do you think it's clear that all of the points that Mr. Uhar was raising here would have undermined the ultimate outcome of the various administrative proceedings, as opposed to just showed misconduct in the process?
So I think there are two issues here, Your Honor. And the first is that, so the board did engage in a lengthy discussion with Mr. Uhar on his exhibits. For example, Exhibit 2, which Mr. Uhar claimed showed an illegal sidewalk cafe, or that Il Canale had made some sort of misrepresentations in getting its sidewalk cafe permit. And what the board said is, Il Canale has presented us with a valid permit for the sidewalk cafe. If you have a problem with how they got the permit, you need to take that to the issuing agency. There's nothing that we can do because we can't review that decision from the agency.
Why do you have to review the decision in its outcome? You know, again, imagine his claim was as follows, and this is much more specific than his claim was presented to the board. I realize that for sure. But imagine that he'd said about the sidewalk cafe, look, I don't know whether the sidewalk cafe permit should or shouldn't have been issued. Don't really care. Don't have anything to say about that. But here's one thing I can show you. He intentionally lied to the agency, and nobody pointed that out to the agency. The agency hasn't ruled on it. It may not have been apparent to the agency, but I now have information that will show that he intentionally lied to the agency in the process. I have him admitting on tape that, yeah, you know, no, everything I said there was untrue. I was lying. I was hoping to hoodwink them. And he says to the DC ABCB, says, you know, I'm not trying to get you to review the issuance of the sidewalk cafe permit. might well have been appropriately issued, don't care, don't know. But I want you to look at my evidence that shows that he's a really bad guy. And you really shouldn't, to the extent his right to have a permit or his ability to be given a permit depends on good character, he lacks it. Is that something that the board should consider, can't consider, could consider, but wasn't required to consider?
Again, Your Honor, I'm having trouble seeing how those don't all intersect. Take, for instance, Mr. Uhar tried to present an insurance document that he said shows that Il Canale did not have proper insurance for the sidewalk cafe. But in order to issue the permit for the sidewalk cafe, DDOT has to assure itself that Il Canale has insurance. So for the board then to come and say, this was, say even, taking Your Honor's example, if to say this was gotten by fraud, this is in a forged document, whatever, that is overriding the DC zoning's decision that this was, or sorry, DDOT's decision that this was a proper insurance document. So when they're looking at,
I get that. I see your line of thinking there. Let me ask you about crime as another line of analysis here. So at the end of paragraph 20, the board says something that your opponent quoted, which is, and I'm paraphrasing now, but roughly to the extent that that Mr. Uhar is trying to say, look, this guy's committing criminal offenses. The idea that we could figure that out when there's no conviction would run contrary to the right to a presumption of innocence. That seemed as though the board was saying, if in the context of opposing a liquor license or renewal of a liquor license, issuance or renewal, and objector says, don't issue the license, I can prove that the person has been engaging in criminal conduct. It makes it sound as though the board just applies a flat rule, which is, sorry, that's not our homework. We can't consider that. The only way to have that be a basis to refuse to give a liquor license or to renew a liquor license would be if it's gotten all the way to the point of a conviction. Is that? Do you agree that that's what the board seems to be saying?
Well, first, Your Honor, I just want to be clear that petitioner did not make this argument in their brief. So I don't think it's properly before the court. But to answer Your Honor's question, I don't think that the board was giving a flat presumption of innocence. I think it's saying we don't have the expertise to or the authority to investigate criminal behavior outside of that related to ABRA laws. And
why? The point is, why is it? Oh, you mean outside that related to ABRA laws?
Yes.
So your point is, just to give a hypothetical, if a defendant, if someone is applying to get a liquor license or a renewed liquor license, and an objector says, by the way, this person, let's say Bernie Madoff, while the criminal charges were pending against him, tried to get a liquor license from the DC ABC board. And an objector said, look, there's he's alleged to have committed all sorts of fraud, and you should not give a multi-billion fraudster a liquor license or renew the liquor license. You think the board could and should say, if that had nothing to do with the operation of the alcohol laws, we don't care. We're going to issue the license. We won't and can't consider that. Even if you can, come in and prove it, we don't care. It's outside our purview, because our good character inquiry, if the conduct is criminal, only relates to good character in connection with the activities, alcohol-related activities.
No, Your Honor, I don't think that that's quite the case. I think the board can look at all kinds of, all manner of things that would bear on character and fitness. In Your Honor's example, what I would imagine what the board would do would be to say, we're going to stay this, the renewal hearing until there's an outcome from the pending criminal case. And the case that petitioner brought up this morning, the mayor case, that's exactly what they did. Is they said, listen, there have been some serious allegations of violations here, and so we're going to suspend the protest hearing until we can until the proper agency, or if it's under ABRA jurisdiction, ABRA can properly investigate this. So it's not as if the board has to turn a blind eye, or it's just, renew, deny. The board can issue the renewal with conditions if it thinks that would satisfy itself for character and fitness. So it can consider.
Let me get to the bribery. Let me get back to I'm sorry to interrupt, but let me get back to the bribery hypothetical, because I want to make sure I understand it. So the hypothetical I had was, imagine that someone objects and comes in and says, don't issue a liquor license in an unrelated administrative proceeding. This person, I have the person on videotape bribing a DC official. And the official will come in and testify to that. Well, that's criminal conduct for sure. And let's say there's no criminal case right now. So there's nothing to stay. You can't really stay the board's process pending the outcome of a criminal prosecution that hasn't begun. Is it your view that the board could properly say, well, that doesn't relate to the alcohol laws. That was some other permit administrative proceeding that had nothing to do with, the alcohol laws, and it's criminal conduct, and there's a presumption of innocence, and we're not really great at adjudicating criminal matters that are unrelated to alcohol, the administration of the alcohol laws. So not our responsibility. That's just outside the scope of things that we're capable of determining in assessing good character.
No, Your Honor, I don't think the board has to turn a blind eye, but I think it's looking at the character.
But in my hypothetical, what should it do? What is the board required to do?
Consider the allegations and whether to take them seriously or whether there's evidence there. I think what Your Honor is what we're coming around to is Mr. Uhar didn't present any actual evidence of fraud. The proffers that he made, for example, if you look at Exhibit 7, Mr. Uhar says that Exhibit 7 shows misrepresentations on behalf of Il Canale's attorney to DC zoning. But what you have in Exhibit 7 is a letter from DC zoning to Il Canale's attorney. So there's no representation, true or false, from Il Canale in Exhibit 7. So there was really nothing.
I take your point that Mr. Uhar's evidence of fraud may not have been that strong, but that really wasn't the board's ruling. The board's ruling about fraud was it's wrapped up in the proceedings of other administrative agencies, so it's not our homework. That's paragraph 19. And then paragraph 20, which isn't explicitly about the fraud in the sidewalk cafe, but seems to be about the other administrative determinations, was those aren't really that significant, so they wouldn't affect our decision. And also, to the extent, well, really, I think partly it was we're not going to consider them maybe, but also in any event, they're not so significant that they would affect our thinking. So the board didn't really ever say, Mr. Uhar is alleging that the applicant here lacks good character because he, intentionally lied to agencies and obtained approvals by criminal fraud. His proof of that is just inadequate, so we're completely unpersuaded. That's not what they said, although that's the point you were just trying to make. They said other things. They said, as to some of it, that's not our homework, and as to some of it, even if it were true, it isn't significant enough to change our decision to that there is good character.
So, Your Honor, again, I like to refer to the actual protest hearing where the board did engage in lengthy discussions with Mr. Uhar about the evidence, and it excluded it. I don't think the board is required in its order to say to talk about evidence that it excluded in its discretion. And I don't think it was an abuse of discretion for the board to look at the proffer and to say that this evidence is not relevant because it doesn't have any bearing on whether or not we can issue the license.
I agree with everything you just said, but you would have thought that the board then in its order, when it was addressing the claim of fraud relating to the sidewalk cafe, would have said, well, he alleges that, but we excluded the evidence he proffered in support of it. And so there's no proof. But that's not really what the board said. The board said that isn't our homework. And I'm not really sure right now. I know some exhibits were admitted and some weren't. I'm not sure about the sidewalk cafe, which exhibit, whether any of those exhibits were in or whether none of them were.
Those were mostly excluded because they went to the validity of the permit from DDOT.
You say mostly excluded, but some were admitted, or?
If I remember correctly, part of Exhibit 5 was admitted. That was the cease and desist letter. Exhibit 6 was admitted because it's part of ABRA's record. That was the increase in substantial change request. And Exhibit 7, which was the supposed misrepresentation from the lawyer. So that is a no, that was DC zoning, excuse me. So I take Your Honor's point that the board could have said more in its order, but I don't think it was required to. It made its evidentiary rulings, and it's, a trial court, just to analogize to a trial court, makes evidentiary rulings all the time. They don't always end up in the order if it's not relevant to the point that the court needs to make. The board is looking at the evidence that was admitted and saying, based on this evidence, we don't see anything here that would make the applicant unfit for licensure. And that's compared to the overwhelming evidence that Il Canale submitted. We have the investigator report, which they visited 21 times, didn't find any ongoing ABRA violations or construction code violations or anything that would deny the permit. We have, 3 witnesses, 2 of them neighbors, that testified as to Mr. Ferruggio's good character. And Mr. Uhar didn't have anything to rebut that. So I think that's...
Can I interrupt and ask you, did you earlier refer to a heck bar?
I was just analogizing, just to say you can think of this court's decision in Kopp and Craig as creating sort of a heck bar in terms
like
of
a heck versus Humphrey. That
yes.
Okay,
Sorry, Your Honor, I should have been more clear.
No. I think I knew what you mean, but so heck is, as I can remember, it's like we don't want people who live in prisons or people who've been convicted of something to like use like a 1983 claim or something to basically circumvent other laws like habeas or EDPA that puts limitations on their ability to challenge their underlying conviction. So there's a reason that we have that heck rule. What is the analogous reason in this context that you drew the analogy? Is there also an underlying point to it all?
Yes, Your Honor. I think it's what this court said in Kopp. A renewal application is not licensed for a protestant to do an end run around other agencies' decisions. Otherwise, you could end up having inconsistent decisions. What if the board did go through this finding and found, hey, there was insurance fraud? Okay, so now we have a DC zoning permit that can't be issued unless there's adequate insurance, which in order to issue it, DC zoning must have made a decision that there was adequate insurance. Now we have the board's finding that there's not adequate insurance because it's a fraudulent document. That trying to avoid those inconsistencies is, I think, I don't want to speak for the court, but my reading of Kopp and Craig is that's precisely why why that rule is there.
Yeah, I think those inconsistencies are probably not ideal, but it's different from heck, where you actually have like two bodies of law that had to be made inconsistent and made consistent because they would clash, which seems different.
I guess I see it as similar here, and if I could just I think Craig maybe gives a good example of this. So again, in Craig, the board's decision was an independent determination from what DC zoning had determined, that this restaurant could have an exception for operating in a residential zone. But the board's determination to look at its statute and say, there are no exceptions here. The statute says that you cannot have an ABRA license. That can stand, as well as the DC zoning can stand. So I guess I think it would undermine agency decision-making for there to be inconsistent decisions. And then it would also be difficult for applicants and many agencies to really understand what their burden is. But again, I think the issue here is mostly that Mr. Uhar didn't come forward with any evidence of the alleged fraud or misrepresentation.
Can I ask you, I touched on this with your opponent, but I want to make sure I understand your view about exactly what the board, the breadth of the board's alternative ruling in paragraph 20 of its order, where it says, nonetheless, even if true, the board is not persuaded that any of the violations. Do you understand that sentence to relate not just to the prior sentence about violations of fire, construction, health, and public space rule, but also to relate to the allegations relating to the cafe, street sidewalk cafe or street cafe?
I think it would, you mean the ones that go to the permit? The fraud allegations?
Yes, the discussion, the allegations discussed in paragraph 19.
So I,
the issuance of, fraud, criminal fraud in connection with the issuance by DOT of the sidewalk cafe permit. Do you understand?
So I don't think that the board was addressing the fraud allegations, because as it said in the earlier paragraphs, it can't look behind the issuance of the document. I take paragraph 20 to be talking about, Mr. Uhar attempted to introduce evidence, a DCRA stop work order and a citation from the fire department for improper propane storage. I took the board to be speaking about those violations when it says that even if true, they're not sufficiently egregious enough. And I think that again goes to, pardon me, I think that finding from the board is based on substantial evidence. And I think this court can maybe get some guidance from looking at ABRA's civil penalty schedule in 23 DCMR 800. There you have a list of primary and secondary violations of what are considered ABRA violations. And so while not completely analogous to public safety or fire, I think looking at what ABRA considers to be a serious allegation gives it reasonable basis to decide that these minor violations, a handful in a span of 10 years of them having their license does not rise to the level of unfit character. Again, sorry.
Go ahead.
Pardon me. And just to touch on one point that was made with petitioner, the board also, it's also in the board's discretion to make evidentiary rulings regarding the subpoenas. The board did not abuse its discretion in quashing the subpoenas, because as it said multiple times at the status hearing, if you have to list the witnesses, and if you don't, and there's no good cause, then the board will exclude them. And that's exactly what the board did. Looking at the evidentiary rulings, the board did not abuse its discretion. Its findings were based on substantial evidence. For those reasons, if there are no further questions, we ask that this court affirm.
Thank you. Ms. Meyer, you have a few minutes in rebuttal.
Thank you, Your Honor.
Could I ask you to clarify something for me?
Sure.
If we assume, for the sake of argument between us now, that the board's quashing of the subpoenas was correct, and that you get no relief there because Mr. Uhar was not had not listed his witnesses as the board had told him he had to do. What evidence of wrongdoing did Mr. Uhar have to present?
I believe he submitted several exhibits, as Ms. Browder mentioned. Certain of them were admitted and certain were not, but he also testified himself at the protest hearing. And I believe it would be mainly his testimony. Another one of his due process complaints, which is minor, but was that Roger Uhar, his brother and resident, was not allowed to testify. So besides the subpoenas, he did submit some evidence, but besides the subpoenas, there's other evidence that he would have liked to have admitted that was not.
Right, but what I'm interested in knowing is whether he actually, when push came to shove, presented substantial evidence of misconduct going to the character issue.
I think a lot of it was contained in the applications to the other agencies. And as we discussed already, well, we're not asking for those to be overturned. Looking
Well,
at
also,
them,
my impression is you don't really have the evidence presented that those applications were false. Is that right?
Well, the frontage of the sidewalk cafe was listed on the DDOT application, I believe, as 70 feet. But if you look at, so I mean, some of the evidence, I guess, would be in the public records. If you look at the plan, I believe it is, of the property, the frontage of 1063 is only 28 feet, whereas they put on the application 70 feet. Similarly with the
How low, and to use a phrase that Judge McLeish used earlier, how load bearing is a discrepancy like that?
well, that's a large
Does
discrepancy.
that show fraud? Does that show some sort of character defect?
Maybe it shows
Maybe an
trying,
error, but
maybe it shows trying to push the envelope a lot. And it also similarly, the alley back garden was claimed that there's a requirement that there be a 15-foot setback, but the entire property was only 15.5 feet. So that was clearly not possible. So I guess a lot of the evidence was the public records. And I think it just shows there's a regular attempt to push the envelope and do a little bit more than is allowed. So even where it's not fraud or flat out lying or perjury, which in some cases petitioner claims it is, but even where it's not that,
I want to distinguish between claims and actual evidence, and actual proof, in other words. See, when the board said that, look, even if we consider these things, they don't rise to the level cumulatively to make a difference to us. Did they include these things you're talking about now?
No, they did not. And also that's part of the significance of the subpoenas, we've discussed, but petitioner couldn't fully present evidence because he wasn't able to have the testimony of 8 people who were possibly.
He was allowed to call either 1 or 2 of those people, right?
That's right, but not all 8 of them.
But he didn't call them.
Unfortunately, as not being a lawyer, he didn't do that. I think not being able to call the other 6 was just stymied his plan. In addition, there was the other Protestant who withdrew, Louise Sagalan, and I think that would have been further evidence. But again, she was denied.
I'm trying to get a grasp of what is the most egregious thing he actually was able to prove, as opposed to claim, showing that there was a discrepancy in the frontage or that the number was a little bit wrong in an application. Does not strike me as substantial evidence of going to the witness's character or going to the applicant's character. So, making a charge of fraud or of bad character requires something a little more incisive. Now, one answer you have is that, well, I had 6 witnesses who I would have been, if he would allowed me to call them. Okay, I get, although I'm not sure what the proffer really is there, but I'm thinking that, to be honest, that the board had every right to say, look, we told you 10 times, or maybe it was only 4 times, that you've got to list your witnesses, and you didn't list them. And we told you what would happen if you didn't list them. I'm not so sure that this court can overrule that board determination.
In addition,
that's an independent ground. So what I'm wondering is whether, if we accept that determination, there was really anything left that could, as a substantive matter, be viewed as overturning the board's determination. That's why I say, what's the most egregious thing that really points to bad character that actually got in the record as evidence?
I believe probably
and that the board didn't discuss.
Construction over the public alley, which was torn down. I think a lot of the some of the more egregious instances were remedied, and I know that respondent said at some point in, I believe, her brief that, well, if it was remedied, who cares? Or I apologize if it was the board that said that and not respondent. But things that were remedied still show that they happened, and there's a series of violations. As soon as one gets remedied, another one pops up. The umbrellas, the heat lamps, there was a blower, the propane tanks, the construction over the alley. Currently there's still, I believe, more seats at the bar than there are supposed to be. It's just as soon as something is remedied, something else, Mr. Ferrugio attempts to do something else. But I would say the most egregious would be the construction over the alley, which was actually taken down because it was clearly, a large amount of construction that he had no, permits for. But I would just
Can I ask
posit
you,
that-
just to clarify one thing, on the frontage of the Sidewalk Cafe where you said, you said maybe the city plan would show it was 28 feet, and he said on the application 70 feet, or Il Canale did. What's the gain there, or is there an advantage from? I didn't quite understand what the issue is.
Well, the size of, he claimed that he had insurance for the entire 70 feet, but he only had insurance for at most 28 feet.
Right.
And so he's operating not only an unpermitted sidewalk cafe, but an uninsured one. And, DCRA is not listed as an additional insured on any certificate for the 1065 property. So if someone gets injured there, in addition, there was a violation where there's a step. The Sidewalk Cafe, I believe, is supposed to be at grade, but it's not at grade. So for example, if someone trips and falls and sues the city and there's no insurance for that, then the city, and by way of taxes, the entire population is held liable. And another difference is that
I understood something, but I thought, but I think I just assumed this, so I may have been incorrectly assuming. Help me to figure out whether that's right or not. I thought that part of the point was if his application to DDOT had been accurate about how much of the property, not the street and sidewalk, but the property of the two addresses, how much of it he owned, he would have not been able to get as big a sidewalk cafe. It would have had to been limited by its dimensions to the property that he owned and was operating as Il Canale rather than the adjacent property. Was that not right? If he had been up front and said, well, Il Canale is at whatever the 1163, I forget which one's 1163 and which one's 1165. Here's where Il Canale really is, but I have an arrangement with whoever, either I own or some other related entity owns, or I have an arrangement with the person who owns the adjacent property. And so I want my sidewalk cafe to be in front, not only of what's been approved as Il Canale, but also the adjacent property. Is that something he could have gotten, or is that something that, in your view, if he had been accurate about the description of the property on the other side of the sidewalk, not the street part, he would have been stuck with a smaller sidewalk cafe? I don't know the answer to that. I'm just not sure.
Well, I think petitioner would be happier with the small sidewalk cafe or no cafe at all. The board does have the ability to deny a license for a previously properly performing, performing party. Yeah, just because of the, lie on one part.
Let me try to just make sure you understand what I was trying to get at. Judge Beck's question was like, what would the motive have been for there to be a false statement to DDOT about kind of how big Il Canale was? And you gave some reasons, and what would the consequences have been? And you gave some reasons. And I was just wondering whether one of the consequences would have been that if he told DDOT the true thing about the size of Il Canale, would DDOT have given it lawfully, appropriately have given him an approval to operate a sidewalk cafe that was bigger and projected out beyond where Il Canale was? Do you know the answer to that question? I just don't know.
I don't know because I'm not DDOT, but I would imagine that they would have said either you need to get more insurance which would protect, the citizens and residents of the district. Or another significance is that 1063 and 1065 are not the exact same size. 1063 has about, I looked on, recently, it's like 3 tables wide, and 1065 is about 5 or 6 tables wide. So there's a large motivation to exaggerate, by Mr. Ferruggio and attempt to get a larger sidewalk cafe that covers 1065, because really about 3/4 of the frontage is 1065, and being limited, even if DDOT said, okay, we're only going to give you a permit for 1063, that's really not that much. And, he's a business owner and would like to make money. So obviously he's trying to get 1065, but DDOT may have either rejected his application, or they may have said, go out and get more insurance. But either way, at this point, a remedy could be by the board could be to entirely remove the sidewalk, or well, not remove it, but to say they can't serve alcohol at it, because any violation when looking at a renewal does give the board the power to revoke a license. And actually, that brings up one point I was thinking of earlier during Ms. Browder's presentation, was that, ideally, petitioner is looking to, revoke Il Canale's license. But as I said in the alternative earlier, or have it with conditions. But also, I just wanted to point out that we're not undermining the agency's decisions, and it's not inconsistent what we're aiming for, because Il Canale can still have a restaurant. It's just the alcohol license that's at issue. And especially when we were talking about Craig, we're not saying that you can't have a sidewalk cafe or a restaurant. We're just saying that the board shouldn't issue an alcohol license there. Maybe turn it into a coffee shop or whatever. Maybe his character is proper for serving coffee, but not for serving alcohol. So it's not inconsistent to say that the other agents, the relationship between other agencies' permits and what the board can do, because they are 2 separate inquiries. We're not asking the board to shut down the restaurant entirely, just to revoke the license to serve alcohol. And I do actually have one final point that I think was brought up by Ms. Browder, if you don't mind. I know I've gone over my time, but when we've been discussing different, remedies, one thing I didn't mention yet, although it was mentioned in, I believe, our brief, if not the proposed findings of fact and conclusions of law. Another error of law, if you compare paragraph 19 of the board's order with this Charcoaltown decision of the board, which I brought up today, which cited Citizens Association of Georgetown versus the DC ABC board, which is a decision of this court in 1972. Respondent had written in her brief, I believe, that, and I believe the board said it as well, that petitioner should just go to the other agencies and ask them to fix these problems. And it's not our business too, and we don't have to do anything about it. Petitioner should just go, talk to the other agencies. And I believe that's actually an error of law when the board said that, because the Citizens Association of Georgetown case actually states any information obtained during these proceedings may be used by ABRA or forwarded to other government agencies to support additional administrative or criminal actions against the applicant, the individual owners, or others. And so that is another remedy that petitioner requests, is referring the evidence of Il Canale's illegal activities to other DC government agencies for investigation and accountability, specifically not necessarily requesting a reference to DDOT or DCRA, or the zoning administration, as we've discussed, but we're referencing a referral, I apologize, to the DC OAG. That is something that the petitioner has requested, that the OAG actually do investigate some of these things rather than just, defending ABRA, but that they actually serve the district and, promote the good of the people. And finally, it's, as I did mention, it's a tax on the citizens of the district to have a one business that is allowed to operate, separately and with different requirements than others. Like, as the Charcoal Town case shows, Il Canale just, has been, they show that there's almost a monopoly, there's barrier to entry, that, old businesses are allowed to operate and, do what they want. But when a new business that, maybe serves a different clientele or has different, heritage and ethnicity, owning it, when they try to move in, they're not getting the same, protection of the laws that, older businesses that seem to, enjoy privileges or special treatment. And if there are no
Okay.
further questions, I think the court, but I think there might be another question. I apologize.
No, I think we have your argument,
Okay,
and
okay, thank you.
the case is now submitted, and the two of you may log off.
Okay, thank you, Your Honor.
Thank you.
This honorable court is now adjourned.